Just when you thought it was safe to get back in the water, COVID says, not so fast. You're going to need a bigger boat. Find out today whether or not you should still have a COVID clause in your contract. Stick around. Out there, everybody, welcome back. My name is Rob. I'm a wedding lawyer representing wedding business professionals. And you've been asking yourself, Rob, well, I guess if you're asking yourself, you're not asking me, but perhaps you're asking someone. Well, we're in the third quarter of 2021. Do I still need to be addressing COVID in my contract? And the short answer, my friends, is yes. As of the date of me filming this, we have one of probably not the last variants doing damage all across the country, not all across the country equally, mind you, but definitely in enough places to cause our governments in different states to re-up the COVID laws. So in terms of COVID affecting events, we are not out of the woods. So if you're not already doing so, you need to be addressing COVID in your contracts. And in my opinion, nothing has really changed. You should still be having a rock solid force majeure clause. You should still be addressing some type of indemnity in your contracts with regard to COVID. But if you weren't already, pay attention. Here's essentially the three reasons why COVID should be addressed in your contract and how COVID should be addressed in your contract. Number one, you really want to be dealing with COVID and its variants, the Delta variant, the Lambda variant, whatever we're at now. You need to be addressing that in the contract in the form of some type of indemnity or waiver. And what I mean by that is you want to make sure the client understands that events taking place in a public space with human bodies being in close proximity to one another is potentially a dangerous situation because of the infectious disease of COVID or whatever the variant is. So understanding that, the client needs to agree in some form or fashion to hold you harmless or to agree not to sue you if someone gets COVID or they get COVID at that event. So that can be done in your contract and should be done in your contract, or I think it's best practices. I'm not trying to give you legal advice. Everybody's situation is different. But in general, you're going to be wanting to address that particular issue. That is the issue of someone getting sick with COVID at the event, whether it be the guest or the client, okay? And you can do that through some type of indemnity clause, and we've dealt with indemnity in other videos, so I won't go in depth on that, but indemnity is one way to do it, in which you are shifting the risk of loss, of damages, of injury from COVID from yourself to someone else, in this instance, probably the client. Or you can do essentially what we call a straight up waiver. In other words, the client is just saying, if I get sick, it's on me, Charlie. Don't worry about it. Some type of waiver. And that can also be extended to the guests in various ways. And we've talked about that, I think, a year ago with guest waivers and ways that we can, minimize the risk of loss if a event attendee gets COVID. But I think that general principle of someone getting sick from COVID should still be addressed in your contract. Second thing is COVID affecting the moolah, the money, the cheese, the cheddar. What happens if the event cannot go forward because of COVID in some way, whether it be some type of law that's passed that's limiting the amount of people that can gather, masks, no masks, you can't have a buffet, you can have a buffet, whatever the case is, establishing the parameters around when the event should be canceled, could be canceled, may not be canceled, what's going on, have that dealt with. And then a more important corollary to that, what happens to the money? Does the money go back to the client if the event cannot be rescheduled or whatever the case may be? Dealing with money, that should super duper with an asterisk, underline, bold, 18-point font, needs to be dealt with in your contract. super duper important. And I've dealt with this in other videos. Be sure to check those out. And then finally, the third thing that I would say that you should be addressing in your contract is the idea that, we've been calling it COVID, and that's true. I guess it's COVID-19. I think if I understand correctly, it's because it came out in 2019. So there could be a COVID-20. There's the Delta variant of COVID-19, as we just talked about. So I think in order to kind of bypass or kind of shield ourselves from any squirrely judges out there, the other thing that I would say is to make sure that the wording in your contract is not so specific to COVID-19 that some judge would read that as only being limited to COVID-19, when in reality you want it to be any type of similar infectious disease. So again, addressing injury, addressing what happens to money if the event can't go forward, and addressing what COVID actually is from a scientific perspective. These are three things that should still, in my recommendation, to the extent that it's not legal advice, everybody's situation different, but these are three things that would be super important for you to consider continuing to have in your contract. And if you haven't had them in your contract, you better think about putting it in there. I do hope that you enjoyed the content of this video. If you have any suggestions for what you would like me to cover in the future, let me know. New videos come out every Monday on YouTube, on weddingindustrylaw.com, and wherever you get your podcasts from. If you have a COVID clause in your contract, let me know. Post it in the comments below. If you don't have a COVID clause in your contract, tell us why you don't have one in the comments below, and maybe we can get a conversation going. Like I said, new videos every week. And with that, folks, we'll see you next time.